We'll plan to go pretty much all day until we finish.
That's what she said.
I'd like to say I'm sure that all of the evidence has been exchanged by now. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial.
Shots at Glanville, not putting his foot down. The Young Thug YSL RICO trial had a status hearing today with the new Judge Paige Reese Whitaker. Judge Whitaker sets some ground rules, such as starting at 8:45 a.m. every day, no eating in court, and limiting defendants' wardrobes. She also asked the state for a realistic number of witnesses and what they will testify to. This new judge is not playing games. She is putting all types of rules out there. She seems fun though, like she laughs a lot and she has a country accent. She throws some shade at Glanville. I don't know if it's on purpose in terms of like why they haven't turned over evidence. And this is basically like a big meet and greet with all the lawyers and establishing what's going to happen next. Like the video right now, join the channel membership. Let's go, boys. All right, here's Judge Whitaker right here. They started on time for once, actually early. No more Judge Glanville's schedule.
Introducing yourselves and tell me who you are representing, and at least for the first part of all of this.
No defendants are present. Now that all the lawyers are going to stand up and introduce themselves, I'll just skip past that.
I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim before we bring them back, as much as we can do, I'd like to do that.
Look at the state all happy that, yeah, bring the jury back. Yes, the trial is going to go on.
Minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable.
Oh, no more Miss Weaver either, typing right there.
A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of, and I mean, I'll look back into that. But a July 18th motion to disqualify two of the prosecutors, pending motions for Mr. Williams that I didn't include.
It's not a motion that filed. May I address that just for your editing?
Sure. And are you going to file it? You're just giving me a preview, or?
I can file it.
Okay.
I'll do whatever the honorable court desires. I just want to bring to the court's attention.
I'm still handing out something else.
Another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. The Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially denied, he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted, the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024, invalid.
Okay.
Everything after the motion to recuse, those dates of testimony of what you have to be, basically, they have to unwind it before that and take away the jurors' notes and shit and tell them to disregard it, and it's invalid.
So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I don't want to, I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here.
They can't really do anything because the defendants aren't present.
I just want you to know that there was a witness testifying. That's why I thought it was important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away, and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name's Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the
All right,
motions.
great.
I know her brain's like, oh my God, here we go. It's already starting a million fucking decisions.
Your Honor, the way that we had been operating under Judge Glanville was there was a thing we named the Harvey Rule, which assumed that all were in agreement and opting into a motion unless we specifically opted out of the motion. So
everybody is joined on everything.
Theo has filed a number of motions that we opt into. The gentleman who's on the stand right now, I think that we need to have a hearing regarding the admissibility of his testimony. I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand.
He's brought this issue up before with Glanville. He doesn't like Woody even testifying at all. The admissibility of Woody's testimony as a co-conspirator.
Okay.
And additionally, prior statements and redacting prior statements. And I believe that
prior statements of Mr. Copeland. Okay.
We would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we
No! Don't tell me that. Don't tell me they're going to go through all the 18 hours of jail footage again, dude.
Probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But
Okay. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously, I'm parachuting in, and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand.
She's laughing like, y'all been doing this shit so long. I'm not changing every ruling. She actually seems kind of cool so far. I know nothing major has happened, but I like her attitude a little bit. She's laughing and shit, not like stern and...
I will, y'all, in a couple of weeks, I'll know all of this. But I just honestly have not been following this case up until now.
How is she going to rule on anything if she's not been following the case? I don't understand. Like I pointed out in my last videos, like cumulative objections, and there's so much evidence that Glanville knew about and ruled on shit. I don't understand. She knows nothing? She doesn't know anything?
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. Why don't I just say that if you are contemplating anything, contemplate it quickly and get it filed
5 business days?
Before the end of next week, because
Okay, so there's a motion deadline pretty much end of next week, it sounds like.
the jury has already been given the week of July 29th off, so they won't be back before August 5th, really.
So the earliest the jury's coming back is August 5th, if everything goes to plan.
If you can, honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, a week and a half since whatever went down. I don't know the exact dates of everything yet, but you don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is. And then I want responses from the state by that Friday, the 26th.
Okay, so now 23rd for the defense to file motions, then the state responds by the 26th.
We will be filing motions, but we have no pending motions.
All right, turning to the state. Are there pending motions by the state that need a ruling?
Thank you, Your Honor. There are, and we will have to the court.
Miss Love back in all her glory. Look at her in her pink little suit jacket.
And there are 2 anticipated motions in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well. There are rulings that have been made long ago. Chart for the court, a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well.
Or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe that includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay, like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
It sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine. But y'all all know Ms. Parker, but Ms. Parker is retiring in 1 week. I will have a new court reporter, and I know, the end of an era.
This old ass lady right here retiring.
Forward, I'm going to ask Judge Glanville's court reporter to start working on transcripts, because I'm going to need them, but we'll all need them at some point probably.
Bunch of bullshit about them organizing exhibit lists, transcripts, and what motions that need to be heard.
Do you have an idea of when you can get me the list of the rulings so far?
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
Okay.
Thank you. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that.
They can't. I was watching Miss Sylvia's stream the other day. Shout out Sylvia. I'll put her channel in the description. She said that some of the jurors have to pick up children and they have to leave by 5 or something. So that's not going to work. So that's already going to be changed to 5 most likely. And I'm having a tooth pain suddenly. So hopefully it's not my wisdom teeth coming in. Please, love of God, no.
All 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties,
She ain't playing games. She's saying, when I mean 8:45, I'm sitting on the bench at 8:45.
defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. So, okay? So I don't want to be waiting around till 9:30 to get started.
Sheesh.
All right, so that's
Okay. It's so refreshing to see a judge that's actually running a courtroom.
that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not gonna be doing that, okay?
Is she talking about Glanville? Glanville used to be eating his McDoubles up there. I'm just kidding. It was like mince and shit. Trail mix. Thug actually used to eat too, so I don't think Thug gonna be able to eat no more.
We are working through lunch. If we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not gonna be eating popcorn. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And
That has to be Thug, right? I'm pretty sure I've seen Thug in like 40 or 50 different outfits, like somewhere around there, so.
a lot for the deputies to have to keep up with. There are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closet. So now I've done that for the deputies. They'll be more happy.
Deputy's getting lazy, bruh. Come on. Organize Thug's clothing, motherfucker. Thug pays your salary with his taxes. It was a joke.
Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now. An issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening.
I've seen that so much of the trial. Like, these motherfuckers just allowed to have headphones on, chilling.
Can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it.
I think it was originally to combat boredom.
All right, well, we won't be bored from here on out.
To combat boredom.
That's the only reason for it. I want to be moving forward efficiently.
She doesn't have the context in her head that they've been there for 18 months already. 18 fucking months. A year and a half in the same room. She knows about that, obviously, but the defendants literally just sit there and don't speak, don't do nothing. So that's why they got headphones, I guess.
How many witnesses there are to go and what you expect those witnesses to say. And one reason I say that
There's like 40 or 50 more witnesses at least.
is Judge Glanville had entered an order that essentially said a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly, because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence.
But how do you know what is cumulative? So you're gonna have to read some goddamn notes, some summaries?
I might end up using that. So how about y'all give me a heads up on all of that? I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional.
Understatement of the century.
And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay?
We all know that's going to happen at some point. I mean, Brian Steele basically called Miss Love a liar for like 30 pages in his supplement.
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court. Okay. Now.
Pieces of communication may be admissible, may not on an individual basis. certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we kind of kick the can down the road a little bit, so they're still outstanding.
Okay.
I just wanted to bring it to
All right, so maybe when everybody is putting their lists of witnesses and what generally going to be talking about together, they could also include if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is, because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now.
Has all the evidence been exchanged?
Would I be correct in saying that?
There's reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing.
All right.
That's been a recurring theme.
All right.
That's been a recurring theme. Schardt is a legend.
Anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively. I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to talk to each other about whether there are any plea negotiations that might be fruitful, whether is any room for movement by anybody on anything. Plea, I'm willing to entertain any kind of plea at any time.
That's her saying, please, everyone just plea out. Please, the state, give them a plea that makes sense. Don't make me do this trial. I'm going to blow my head off.
Invite during this pause. If y'all want to think about that and talk about that, now would be a good time to do that. I'll convene here at 8:45 and just start tackling everything that got filed, okay?
So next week is going to be nothing but motions being filed and then the state's responses. Then they come in on the 30th and hash it out, boys. It's going to be goddamn like Avengers Endgame.
We'll plan to go pretty much all day until we finish.
That's what she said.
And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. If this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial.
Shots at Glanville, not putting his foot down.
I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, so I'd like to know it. But I want it to be a legitimate, valid concern, evidentially, constitutionally. I don't want it to be, here's my chance to challenge everything under the sun. I don't intend to revisit rulings on evidence that's already come in.
Her accent is funny. I have no idea what y'all filed.
I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand. And the state knows, we're in the state's case right now, the state knows what it's doing, the state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go.
Can I assume, Judge, that we are going to continue with the opt-out rule so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
This feels like a new teacher. Probably get to a classroom and your teacher left in the middle of the school year. Learn how she does the whole classroom and everything.
Keep rocking as before. All right, thanks everybody.
I like her. She's got good energy. She's laughing. She got a country accent. She's saying y'all. Some funny rules though about the wardrobe. No eating is smart. I hated hearing people eating. Especially, it was mainly Glanville I heard eating. And it seems like she's not playing fucking games. And this trial actually could be fair and be fast. And hopefully she makes the state abide by the rules actually that she sets, unlike Glanville did. Hit subscribe. Join the channel membership. Love you guys.